Supreme Court hands down judgment this morning in the case of T child. I should explain that the court has ordered that no one shall publish or reveal the name or address of T, or publish or reveal any information which would be likely to lead to the identification of T or of any member of her family in connection with these proceedings. This is a brief summary of the court's reasoning. This appeal raises important questions of law as to the use of the inherent jurisdiction to authorize a local authority to deprive a child of his or her liberty. The background to the litigation is the shortage of provision for children who require special limitations on their liberty. This shortage has forced local authorities to seek orders under the inherent jurisdiction authorising alternative restrictive placements of children elsewhere than in an approved secure children's home. These proceedings were begun by Caerphilly County Borough Council to address the care of T, who was then a 15-year-old in the council's care by virtue of a care order. In view of T's particular needs, the council intended to accommodate her in a placement in England, which was not a registered children's home or approved for use as secure accommodation, in circumstances which involved her being deprived of her liberty. It applied for an order under the inherent jurisdiction, authorizing it to deprive T of her liberty there. The order was granted. After that placement broke down, the court authorized the council to deprive T of her liberty in a registered children's home in England, which was not approved for use as secure accommodation. T's position before the judge was that she wanted to be in each of the placements, that she consented to the restrictions on her liberty, so that there was no need for a court order. The judge took the view that an order was required because, in his assessment, T's consent did not have what he considered to be the required authentic and enduring quality. T unsuccessfully challenged that approach to the question of her consent before the Court of Appeal. In contrast to her position before this court, it was not then part of her case that the inherent jurisdiction was not available at all as a matter of law, as a vehicle by which to authorize her placements. T's appeal to the Supreme Court raises two main issues. The first is whether it is a permissible exercise of the inherent jurisdiction to make an order authorizing a local authority to deprive a child of his or her liberty. T argues that such an use of the inherent jurisdiction is barred by the Children Act 1989 and is contrary to Article 5 of the European Convention on Human Rights. The second issue is the relevance of T's consent. T argues that consent is highly relevant and that as she consented to the placements, it was contrary to her best interest to make the orders. These issues are no longer of relevance to T personally, whose circumstances have changed, but they continue to affect a significant number of children. The Supreme Court dismisses T's appeal for the reasons set out in the main judgment given by Lady Black and in the concurring judgment given by myself. Lady Black's reasons for dismissing the appeal in relation to the first issue can be summarized as follows. Local authorities in England and Wales have statutory duties to protect and support children. The statutory regimes in each jurisdiction include provisions for placing, in limited circumstances, a child who is being looked after by a local authority and who is at risk of harm in secure accommodation provided for the purposes of restricting liberty. Regulations provide that a children's home must only be used as secure accommodation if it has been approved for that purpose by the Secretary of State for Education in England or by the Welsh ministers in Wales, and that children's homes must be registered with Ofsted in England and the Care Inspectorate Wales in Wales. Any person who carries on or manages a children's home without being registered commits an offence. The shortage of placements has prompted local authorities to seek orders under the inherent jurisdiction, authorising them to deprive children of their liberty in other accommodation. The inherent jurisdiction is a means of providing protection for children whose welfare requires it. It has been described as the great common law safety net, which lies behind all statute law. It is subject to limits, but those limits do not prevent recourse to the inherent jurisdiction in a case such as this, where the local authority already had parental responsibility by virtue of a care order. It is unthinkable that the High Court should have no means to keep children safe from extreme harm. If the local authority cannot apply for an order under the statutory regime to deprive a child of her liberty because there is no secure accommodation available, the inherent jurisdiction can be used to fill that gap. Where there is absolutely no alternative, and where the child or someone else is likely to come to grave harm if the court does not act, the inherent jurisdiction may be used to authorize a local authority to deprive a child of his or her liberty, notwithstanding that the placement will be in an unregistered children's home, in relation to which a criminal offence would be being committed. The use of the inherent jurisdiction in these circumstances does not breach Article 5 of the Convention, given the safeguards which the courts have devised, in particular by broadly mirroring the procedural protections applicable under the statutory regime. I note in my concurring judgment that any order made under the inherent jurisdiction to authorize a deprivation of liberty where the placement is in an unregistered children's home does not authorize the commission of a criminal offence, nor does it prevent an offence from being committed. I also note that such a placement may be justified and required where the positive operational duties to take steps to protect life or prevent inhuman or degrading treatment under Articles 2 and 3 of the Convention are engaged. But this is a temporary solution developed to deal with an extremely difficult situation caused by a scandalous lack of provision. The appropriate permanent solution is the provision of appropriate accommodation. In relation to issue 2, Lady Black notes that a balanced and free decision made by a child may be quickly revised. That is illustrated by the facts of this case, where T's behaviour in the first placement confirmed the judge's view that her consent was not genuinely expressed. There is therefore no factual basis for T's argument that her consent to the restriction of her liberty made it wrong for the judge to grant an order authorising it, and her argument on this point is academic. T's appeal must therefore be dismissed.